Good afternoon, everyone. Thank you for joining. I'm Rachel Crean. I'm a partner in the litigation team at VWV, and I head up the healthcare litigation team. My team carry out a full range of work on commercial disputes in healthcare, and one of the areas we specialise in is procurement challenges. I'm going to be joined today by Stephanie Wickard, who's a procurement specialist, and she helps both providers on who are putting in bids and also commissioners on how to run procurements within the rules. So we're here today to talk about the provider selection regime, the new procurement regime for healthcare, which came into effect in January. We're going to run through commissioner powers, the 5 routes by which they can commission contracts. We're going to have a little look at trends in award decisions since the new regime came into force. We're going to compare the old and new regime, look at powers to challenge commissioner decisions, have a look at the appeal decisions that have been made since the new regime came into force, and end with some top tips. I'm hoping by the end of today's session, you know a little bit more about commissioner powers to commission contracts, such that you can get involved in those at the right kind of the most useful time for you, and potentially so that you can influence commissioner decisions about what is the correct power for them to use in a way that helps your organisation. I also want you to be able to challenge commissioner decisions when they're getting it wrong, which happens fairly regularly. So a quick look at why we're here. So the provider selection regime was brought in by NHS England, and the stated aims were to reduce bureaucracy and cost, promote flexibility, and support the wider integration agenda. I think the reality is the NHS was fed up with the restrictions on its ability to commission and the amount of money and time being spent on procurement and procurement challenges. I think it's fair to say that the NHS had developed a bit of a reputation for not consistently running procurements well, such that it was potentially good option to challenge them if the result didn't go in your way. I've dealt with a number of cases where we told clients that they had grounds for challenging a procurement decision, but that we wouldn't put their prospects of success more than 50%, and it wouldn't be worth actually issuing court proceedings and spending significant amounts of money. But after sending some aggressive letters, the commissioners back down, indicating that they could see there were problems with the way they'd run their procurement. And that was just a small snapshot that we were aware of. That must have been replicated again and again. So just looking at what's in scope of the new regime, in scope are healthcare services arranged by the NHS. There's a list of CPV codes in Schedule 1 of the PSR. It doesn't list all the CPV codes that exist. So, for example, chiropractic services have a CPV code, but that code is not listed as falling within the scope of the PSR. So first point of call is look at Schedule 1 and check the CPV codes. Out of scope is goods, consumables and devices, even if they're healthcare, social care services and health adjacent services. Mixed procurement can be covered, provided that the main subject matter, by which they mean the value of the contract, is healthcare services, and the other goods and services couldn't reasonably be supplied under a separate contract. So an example of this would be patient transport coupled with delivery of a regulated activity, something that required CQC registration. That would be in scope. Patient transport without delivery of a regulated activity would be out of scope. And if the contract is for both, you can consider whether the mixed procurement provisions apply. There aren't any value thresholds, so all commissioning falls under the PSR. And do bear this in mind when Stephanie comes to feedback some of the award decision data. It's also probably worth mentioning the PSR applies to modifications of contracts that take place since the new regime came into force. So even if the existing contract was commissioned under the old regime, if you were changing that contract now, it falls under the new regime. So moving on to look at the 5 routes by which commissioners can commission contracts. So there's 3 direct award routes and 2 competitive procedures. Direct award A is available if there's an existing provider of services and the commissioner is satisfied that the existing provider is the only one who can deliver the services due to the nature of the relevant healthcare services, and if it's not a framework. So if those apply, Direct Award A must be used. The Commissioner has an obligation to keep a record of its decision that the competitors are not realistic alternatives, and it has to publish an award in FTS within 30 days of the contract being awarded, and that has to confirm details of the contract, including contract value, timescales, and identity of the contractor, the process followed, the decision makers, and conflicts of interest. There's no obligation to publish an intention to award notice. So there's no obligation to put anything out publicly to say we are going to enter into this contract, and no standstill period, meaning that the options for challenge are limited, but I will come back to that point later on. Direct Award B, this applies where the contract relates to a healthcare service where patients are offered a choice of provider and the number of providers isn't restricted by the Commissioner, and the Commissioner will offer contracts to all providers that meet its requirements. And the Commissioner has in place arrangements to enable providers to express an interest in providing the healthcare service. And again, not a framework. If those all apply, Direct Award B must be used. And this covers things like contracts to do with eyes, ears, feet. So things like ophthalmic contracts for mandatory eye tests would fall under this. As with Direct Award A, they don't have to publish anything in advance to say they're considering entering into a contract. The only obligation is to publish details of the contract once it's been awarded. So again, no standstill period. The Commissioner must keep a record of its decision and issue an annual summary of the Direct Awards. Moving on to Direct Award C, this is where it starts to get a bit more interesting. Before the PSR came into force, there was talk of the NHS wanting greater powers to be able to roll over existing contracts. And this is the provision that came of that sort of discussion. So this can be used where the term of an existing contract is due to expire and the Commissioner wants to issue a new contract to replace that one at the end of its term. The considerable change threshold isn't met, and I will come back to explain what that means in a minute. The Commissioner thinks the existing provider is satisfying the existing contract and will likely satisfy the proposed contract to a sufficient standard, and there's key criteria to be applied. And again, not a framework. And here, the Direct Award C may be used, or they could choose to use one of the competitive procedures. So the considerable change threshold is met where the new contract is materially different in character to the existing contract when the contract was entered into. But it specifically says this doesn't apply where the changes are due to corporate changes, including takeovers and mergers and that sort of restructuring. Or the considerable change threshold is met where the changes in service are attributable to the decision of the Commissioner and the lifetime value of the contract is £500,000 or more higher and at least 25% or more higher compared with the lifetime value of the existing contract when it was entered into. And when you're comparing values, you take into account any kind of planned contract extension. So often you'd have a contract that was, say, 3 years plus a possibility for a 2-year extension. You take into account the full 5 years. But if there had been unexpected additional extensions, for example, if the contract had to be extended because someone challenged the procurement process initially, then those wouldn't be taken into account. It also says the value thresholds don't apply if the change is in response to external factors beyond the control of the Commissioner and the provider, including changes in patient numbers or changes in price in accordance with a formula provided for in the contract documents. So this slide just summarises the steps the Commissioner has to take when using Direct Award C. So it has to make a decision. Commissioner has to make a decision taking into account key criteria and applying basic selection criteria, whether it's content the existing provider is satisfying the original contract and will likely satisfy it to a sufficient standard. Has to keep a record of that decision. It publishes a notice of its intention to award the contract to its chosen provider on FTS. So that is it publicly saying we are planning to award this contract to X body before the point where it's entered into the contract. We then have a standstill period, and if there are no challenges brought and the standstill period expires, the contract can then be entered into, and the Commissioner has an obligation to publish a contract award notice. just looking at the key criteria and basic selection criteria. Key criteria, these will be familiar to, I think, anybody who's participated in a procurement under the new regime. It's quality and innovation, value, integration, collaboration, and service sustainability, improving access, reducing health inequalities, and facilitating choice and social value. All the key criteria must be considered, and the expectation from the guidance is that none will be discounted, but no directions given as to how they should be balanced out. Annex D of the guidance has quite a detailed explanation of each of the key criteria. So if you're not already familiar with it and you plan to bid for contracts in the near future, I would recommend digging it out and having a good read. I would also recommend reading it sooner rather than later, not leaving it till you're just about to fill in a response to a ITT, because it may be that you need to do some reflecting or make some changes to your plans or where you do things to be able to answer the questions in the best way possible. And some of it's quite interesting. So they, for example, when they're talking about the section about value, it says it's not just who's the cheapest, but they'll also take into account things like who is going to improve the health of the population such that they need healthcare services less going forward. And they also mention the costs of mobilisation, which seems to indicate that there may be kind of weighting in favour of the incumbent on the value question. Basic selection criteria is determined by the Commissioner. All the basic selection criteria requirements must be related and proportionate to the subject matter of the contract or framework criteria. And the basic selection criteria may relate to suitability to pursue a particular activity, economic and financial standing, and technical and professional ability. But there's no requirement for the authority to have reference to all of the basic selection criteria, although I would be surprised if they didn't. So moving on to the most suitable provider process, this is the first of the competitive procedures. And in summary, this is where the Commissioner draws up his own shortlist and then assesses the candidates. So this can be used where the Commissioner is not required to use direct award A and B and doesn't wish to use C. And the Commissioner is of the view, taking into account likely providers and all relevant information, that it's able to identify the most suitable provider. And again, not a framework. This is quite a new power for NHS commissioners to have, and it introduces a kind of new obligations on the Commissioner to be aware of the local, well, not just the local market, aware of the potential market for a contract. And there's quite a lot in the guidance about it, and there's a section on the guidance that I've seen quoted in quite a few places, but it's got some interesting things, so I will just read out some of it. The guidance says the relevant authorities are expected to develop and maintain sufficiently detailed knowledge of relevant providers, including an understanding of their ability to deliver services to the local, regional, national population, their varying actual or potential approaches to deliver services, their capabilities, limitations, and their connections with other parts of the system. They said that they expect this knowledge to go beyond knowledge of existing providers and to be a general feature of planning and engagement work. So it's quite a high expectation on the commissioners to understand who might be interested in bidding for contracts or being in the running for contracts. The guidance also says the Commissioner may consider organising market engagement events, roundtables, or meet the buyer days as part of their pre-market engagement exercises. And the types of activities that are appropriate might depend on the size and complexity of the services and contracts on offer. So this all gives providers something to reflect on. What steps do you need to take to make sure you're getting on the shortlist for contracts that you might be interested in? How are you going to engage with these market engagement events? How are you going to make sure you're aware of them? Who are you going to send to get the most out of them? So again, I've just summarised the steps the Commissioner has to take to use this route. So the process starts by the Commissioner publishing a notice of intention to follow the most suitable provider process, and it then waits 14 days. The notice doesn't have very much information in it at all. All they're required to include is the CPV code, details of the decision makers, so it doesn't have to list the selection criteria. So that 14-day window is your opportunity, if you've signed up to the FTS alerts, to write into the Commissioner and say, I'm interested, put me on the shortlist, and I can deliver the services that you're planning to commission. So after the 14 days, the Commissioner identifies potential providers who may be the most suitable provider with reference to the key criteria and basic selection criteria, and they should inform providers that they are being considered. Next step is to assess the potential providers. The Commissioner may ask for more information, but this must be proportionate to the contract. And I'd be interested to hear from anyone on the call whether you've been involved in this and have experience of how much information the Commissioner asks for. I've had experience in a slightly different context where a GP contract held by a GMS contract held by a GP partnership. The GP partnership dissolved, and the Commissioner, under some new guidance that it issued this year, said it had the power to decide which side of the GP partnership split would continue to hold the contract. And in order to make that decision, they issued a questionnaire that was a 2-page questionnaire limited to 3,000 words for response, and it was modelled on, I'll just go back to it. It was modelled on the key criteria. So the questions were things like, please describe how you will provide quality and innovation, and please describe how your model of delivery will present value. And it just went through all of the key criteria. So I suspect that that's the sort of information that they'll be asking for. So the Commissioner assesses the information it has, asks for more information if it needs it, and decides who to award the contract to. The Commissioner then has to publish a notice of intention to award the contract to its chosen provider on FTS, and then the standstill period is held. And assuming no challenges, or once those are resolved, the contract can be entered into, and a contract award notice must be published. The guidance also says there must be an ongoing assessment by the Commissioner of whether it has sufficient information, and if at any point it doesn't think it does, it should be abandoning the most suitable provider process and reverting to a full competitive procedure. So moving on to the competitive process, this will be more familiar ground. This applies where the Commissioner isn't required to use direct award A or B and doesn't want to use C or most suitable provider process, or if it is, to conclude a framework agreement. So running through the steps that the Commissioner has to take, the Commissioner establishes a contract or framework agreement award criteria, taking into account key criteria and applying the basic selection criteria. The ITT is published on FTS. Bids are collected and evaluated in accordance with the award criteria. The Commissioner makes its decision, issues an outcome letter to successful and unsuccessful bidders, and must provide reasons. So you'd be familiar with those sorts of letters from under the old regime. It publishes their notice of intention to award the contract to its chosen provider on FTS. It then has to observe a standstill period before the contract can be entered into, and the contract award notice must then be published. Okay, I'll hand over to Stephanie to have a look at data.
Thanks very much, Rachel. We thought it would be interesting to see if there are any trends emerging from the application of the PSR. The data does come with a bit of a health warning because we're not really comparing like for like, and under the under the full procurement regime, obviously there's not a requirement to publish transparency notices for light touch regime in the same way. So prior to the introduction of the PSR, we found 43 direct awards in health and 57 using competitive processes, but I think that figure is probably on the light side. If you compare that to the notices published since the introduction of the PSR, and these figures are to the end of or to mid-October. So the direct award A and B are broadly the same numbers, but you can see that there is a real emerging trend to use direct award C, and there is some use of the competitive procedure, but as you might expect, given the purpose of the PSR, it's relatively low. And I suppose the reason for direct award C, looking at it practically, is that it's much easier to extend the existing contract, but it does, of course, provide the incumbent with an advantage. So as Rachel explained earlier, part of the reason of the PSR is to reduce the administrative time and resourcing going out to tender, so that makes sense. But of course, there are some downsides with direct award in that it can potentially restrict competition and innovation and can have bias built into it. On the next slide, I have carried out a comparison of the PSR and the full fat procurement regime and the Procurement Act, which is coming into force on the 24th of February. One of the interesting points is that there are obviously some concepts used in the PSR that are being applied under the new Procurement Act. Now, where the two regimes diverge is their starting point, is that clearly under the PSR, the starting point is to go down the direct award route if the conditions are met. But under the Procurement Act, there is a clear presumption in favour of the competitive process unless you can meet the sort of narrow awards for direct award under the regime. So there is statutory guidance that accompanies the PSR, which commissioners have to have regard to. There's a lot of guidance being published on the Procurement Act, but actually that's not statutory. But contracting authorities need to have regard to the objectives in the Procurement Act, which is value for money, which is ensuring that bidders are placed on an equal footing unless there's some justification for that. And they have to have regard for the National Procurement Policy Statement. Some of you are aware that at the moment there is none, and the government is in the process of consulting about the new one. So where the processes are similar is in relation to the competitive process. So these are very flexible procedures and can involve steps that the commissioner or contracting authority think is going to best meet its requirements, because of course under the procurement, under the PCR, you've got healthcare services that fall within the light touch regime. I've mentioned the application of the selection criteria because this is where the regimes diverge. So Rachel has mentioned that when you're using the direct award procedure C or the competitive routes, you have to apply the fixed criteria that are set out in the legislation. Under the public contracts regs, the conditions of participation are relatively flexible. A contracting authority can only ask for conditions of participation to the extent that they're proportionate related to the contract. Now, conditions of participation is the new word under the Procurement Act for the selection criteria. One of the themes of the Procurement Act is we're getting changes in terminology, which is slightly confusing. The other point of convergence is around the standstill period. So again, standstill periods are only provided for under the PSR if you're using direct award process C or the competitive processes. And if you want to extend the standstill period, a supplier needs to make a representation to the commissioners and meet the criteria for needs to set out a written notice setting out the grounds for challenge in order for the standstill period to be extended. Now, one of the big changes under the Procurement Act that's coming in is in relation to standstill periods for light touch regimes. So the current position is that there must be a standstill period that is put in place, but that's going. So that's quite a big change that we're going to see under the Procurement Act. I think probably the biggest feature that is different under the regimes is the remedies, and there's a much narrower scope of remedies under the PSR, which, as Rachel has explained, is part of the objectives. And Rachel's going to talk about that in the next slides.
Thanks, Stephanie. Yes, so moving on to challenging award, this is all, very different to under the old regime. The PSR provides a system for you to challenge an award under direct award process C or the two competitive processes. It doesn't apply a route for challenge with direct award A and B. To allow time for a challenge to play out before the contract's awarded, a standstill period, by which we mean a pause on the procurement, begins on the day after a notice of intention to award or conclude the contract is published on FTS, and it ends at midnight at the end of the 8th working day after the day the standstill period begins. So let's say the notice of intention to award went out on a Friday, you start counting the days from the Monday, and it's a week Wednesday at midnight that the period ends. So any provider may make written representations to the commissioner during the standstill period. And then that triggers an internal review. If you're unhappy with the outcome of the internal review, you can then escalate with a referral to the Independent Patient Choice and Procurement Panel, which I'm just going to call the panel. So if you trigger an internal review, so if you write to the commissioner within the standstill period, the commissioner must give you the opportunity to further explain or clarify your representations as appropriate. I don't want you to take this as thinking that you can put in a one-line challenge within the standstill and that you'll have the opportunity later to put in more grounds. I think put in everything that you can within the standstill period, because the commissioner may only give you the opportunity to comment further if they think they need more to understand what you've said. The commissioner has to provide you with an indicative timeframe for a response, provide you with some information that it's required to keep under Regulation 24, including records of decision making. It then has to consider and review the evidence and information available, identify whether your representations have merit, and decide whether to return to an earlier step, abandon the process, or award the contract as originally intended. And then it must communicate that decision promptly in writing to the provider and the winning bidder, leaving another 5 working days before the standstill period closes. So in that 5 working day period, you've got your window to escalate it to the panel. So the panel is something that's been created by NHS England. At the point the PSR came into force in January, it wasn't fully set up. At that point, they had a panel chair, but they didn't have panel members. They were still advertising for them. I had a snoop at the advert, which said that no particular qualifications were required. It said your experience could be in procurement, healthcare contracting, commissioning, legal or other commercial domains, and they were going to be paid a daily rate of £350. The ad said the panelist role would be to consider detailed analysis of representations and initial advice drafted by caseworkers, and will conclude whether relevant authorities have acted in accordance with PSR. And we don't know what sort of experience the people who are the caseworkers have. In practical terms, the process is within that 5 working days of the internal review outcome decision, you have to complete a pro forma on the website for the PSR review panel. And it's a quite straightforward 4-page form, which mostly just asks basic questions about the provider and the commissioner and the type of procurement. And it asks you to summarise your concerns and identify which provisions of the PSR have been breached. And once you've submitted it, it then asks you to send in copies of the documents relating to the internal review that the commissioners carried out. So there isn't, the expectation is that you aren't drafting extensive additional representations at this stage, which I suppose is another reason to make sure your representations as part of the internal review are as comprehensive as possible. You can't skip the internal review stage or the panel won't accept the referral. And the SOP for the panel says any representation should, unless there is good reason, only address matters that have previously been raised with the relevant authority. So on the one hand, it may be possible to carry out the internal review process with limited or no legal input. On the other hand, you need to be careful not to miss out on arguments that you want to try and rely on at a later stage. When submitting your representations, think about how commercially sensitive is the information that you're providing. I found the information about in the guidance about confidentiality a little bit confusing. The terms of reference say, tell the panel if your information is confidential, which would suggest that they will then keep it confidential, but it then goes on to say general requests for confidentiality will not be accepted. And this includes any commercially sensitive information shared by providers or commissioners. So it's not clear how confidential your information will be treated. So think carefully about what you put in and how necessary it is if it's commercially sensitive, and certainly flag it to them if you think it should be kept confidential. The panel will respond to confirm whether the referral has been accepted, and if so, set out a timetable. And the aim is to complete the whole review process within 25 working days. Which is dramatically different to how things would play out in court, where we're telling you to anticipate 12, 18 months, 2 years for the whole process to play out. The panel has acceptance and prioritisation criteria, which mostly reflects the rules. But one point to note is that the panel will only accept a case where the commissioner has decided to press ahead with the contract award. So if after the internal review, the commissioner decides to wind back the process a bit, but not completely abandon it, then you would have to wait for a second contract award decision to be made and go through the internal review process again before you can refer it to the panel. And you just need to be mindful of potential judicial review deadlines if you're waiting for all of that to play out. In terms of prioritisation, it states that its maximum capacity is about 10 cases, after which it may need to consider declining cases. And it sets out some prioritisation criteria, so things about the importance of the issue to the public and patients. So it'll be interesting to see to what extent they use the power to decline to review decisions. And at the moment, they don't seem to be hugely busy. So once it's decided to accept your case, it will review your representations. It can request additional information. It can meet with the provider, but I query how often that would actually happen. I would be amazed if they were meeting with providers on a regular basis. The chair can ask subject matter experts or others to assist. So I assume that means ask lawyers, accountants, clinicians. A report is then prepared and shared with the commissioner, and it has to identify whether or not there's been a breach, and if there has been a breach, whether it has any material impact or not, in which case they can carry, if no material impact, their advice will be to carry on as they were, or the advice may be to rewind the process or to abandon it entirely. The advice or a summary of the advice will be published. The commissioner has to review the advice, and then the commissioner itself makes a new decision as to whether to continue, rewind or abandon. That decision gets published, and they wait, if they decided to press ahead, they wait another 5 working days before the contract can be entered into. So we've reflected a bit on the kind of pros and cons of the new routes for challenge under the new regime. I think it really does give potential to challenge without as much legal input and without the high court fees that were applied under the old regime. So under the old regime, your lawyers would often be telling you you need to issue the claim within a matter of days to protect your position. The court fee is £10,000. If you end up deciding not to pursue the case, you're not going to get that back, and it's going to cost you the same again to get a barrister involved and get the court claim actually issued. So providers are having to make decisions about large sums of money very quickly and without having the benefit of having all the facts, because when you start a procurement challenge, the commissioner holds all the information and you hold very little. So here there's the potential of 2 rounds of review, and the potential for a decision to be overturned without having to go spend anywhere near that sort of money. Although query how often the internal review is ever going to end up in a different outcome to what's happened in the first time round. There's an automatic entitlement to decision-making information, so specific transparency requirements and express record keeping requirements on the commissioner, and providers can request the transparency documents in the standstill period. And anyone that's been involved in a procurement challenge under the old regime will know how difficult it can be to get basic information out of the commissioners. It sometimes feels like every request that goes out, the automatic response is, this is just a phishing exercise. It's got nothing to do with your claim and you're not entitled to it. And you end up having quite a battle just to get information. If you do need to escalate to court, you can potentially wait until the outcome of the procurement is known before challenging, but beware of judicial review limitation deadlines. Under the old regime, because there was you had to issue a claim within 30 days of being aware, or the date when you ought to have been aware of your grounds for challenge. If there was a problem early on in the procedure, so with the ITT documents, it potentially meant you had to issue a claim before you knew the outcome of the procurement. So before you even knew whether, before you knew you may be the winning bidder, and yet you're having to challenge the procurement. And here there's more potential to let it play out and see whether you are you haven't won before you're going down that route. The panel has a reflection and review function, which is potentially helpful. So this is mentioned in its terms of reference. It says one of its roles is to review themes and issues arising from the advice and how they may apply more widely. So if you only ever challenge one procurement, this won't be relevant, but if you're finding yourself challenging multiple, this putting in your reps for a particular challenge could be an opportunity of bringing a recurring problem to the attention of the panel. The cons is the limited opportunity to challenge an award under direct award processes A and B. They have no standstill period, so you can't trigger the internal review process and can't go to the panel. There are more limited options to challenge in court. So under the old regime, you would usually issue a claim in the Technology and Construction Court, applying for the process to be abandoned and claiming damages, or you had the option of going down the judicial review route. Judicial review only undoes decisions. There's no automatic ability to claim damages. So this means the threats of legal action, which can sometimes lead to commissioners backing down before you have to go to the expense of issuing a claim. The threat of a judicial review is probably less of a threat than a threat of a claim in the Technology and Construction Court where you included a claim for damages. It is still a threat because it's expensive and time consuming for a commissioner to deal with the challenge, but they're probably aware that it's going to be a more limited pool of providers who could really bring a claim and see it through in circumstances where damages might not be available. There's also no automatic suspension under the new regime. So if at the end of the internal review and panel review process, or kind of alongside that, you end up issuing judicial review proceedings to challenge the commissioner's decision, that won't put a pause on the award of the contract. And so you'd have to apply for an injunction to get one to stop the commissioner from entering into the contract. Under the old regime, if you issued a claim within the standstill period, the procurement was automatically suspended, and then the commissioner couldn't award the contract without first applying to court to have the suspension lifted. And that was potentially an application that could cost them a six-figure sum or more. So we've had a look at the panel decisions to date. I think I was a little bit sceptical that even the panel would be properly scrutinising what NHS commissioners had been up to, but we've had 3 decisions and they've all found in favour of the challenger. They've all found in favour of the provider. And I'll just run through them quickly now. So one was a challenge to the use of Direct Award C, and it had been used to appoint someone for online ADHD services. The panel concluded that the Commissioner's use of Direct Award C breached the PSR because it's a service where patients should have a choice of provider and the Commissioner shouldn't be limiting the number of providers. The panel advised abandonment of the process and that it should be rerun using Direct Award B. The whole thing was very swift. So the initial notice of intention to award the contract was 26th of March and the panel decision was 15th of May, so only a few months. The second one was a scoring and fairness challenge, and this related to a same-day urgent care unit service. The panel found that there had been breaches of the PSR, both in relation to the way the scoring had been done and in fairness in the way that different providers have been treated. The panel advised that there should be a mini competition between the winner and challenger. This slightly confused me because this isn't something that the guidance or the PSR said they had the power to suggest. But in this case, there were only 2 bidders. And in those circumstances, you'd think this would have meant switching to the most suitable provider process if the panel was suggesting they should do it again. But the panel seemed to think they had the power to run a mini competition or otherwise abandon. Again, the timelines are really short. The notice of intention to award the contract was issued on 11th of June and the panel decision was on the 6th of September. And then finally, there was a challenge to the use of the most suitable provider process and the fairness in the way the process was carried out. Again, the panel found multiple breaches of the PSR, including a failure to consider all potential providers, a predetermined outcome, unfair CQC requirement, lack of transparency and unequal treatment, and they advised abandonment of the process. And again, very short timescales. So notice of intention to award the contract was 5th of July and the panel decision was 9th of September. So I think the takeaway from that is the panel will scrutinise what's going on and it could be worth putting in a challenge. Okay, I'm just going to hand back to Stephanie again, if I can, for tips when bidding.
Yeah, so of course, our advice is always put in the best bid that you can and try and keep the commissioner on the straight and narrow to avoid a situation where you are a disappointed bidder. So we thought we would try and give some practical advice on top tips when bidding. Some of these are fairly obvious, but sign up for the find a tender alerts to get ahead of the transparency notices. I think the second point and third point go together, which is it's really important now with the new processes that the commissioner knows what you do and the extent of all the services that you provide. So when they are considering the direct award processes, that they have got full information. And one of the ways that you can do that is in participating in market engagement. But we'd be interested to hear if anybody has been proactively trying to provide commissioners with information on how that's being received. And then when you are actually given the opportunity to participate in a competitive process, ask clarifications early on to make sure you understand the requirements. And sometimes the requirements may not be as clear as you would like. So it's perfectly acceptable to go back and just really understand the intent behind some of the requirements or ask questions about the approach to evaluation. Does it make sense how they are going to evaluate? Have they set out what the award criteria are and the importance of the weighting that's going to be given to each of the criteria? And then once you understand that, you can start responding to the questions. It sounds a bit silly to have to say it, but make sure you answer all parts of the questions. Sometimes there are a question that has been divided into multiple parts, and it's very easy to miss parts of that question. And have regard to the award criteria when you're answering that question so that you address all of the points. Check the word counts, because sometimes there's an automatic cutoff if you exceed the word counts. The other point that is not on the slide but is worth mentioning is check the instructions in the invitation to tender about cross-referencing. Very often you will get different parts of a tender response which is evaluated by different bidders, and they will only be sent the information that's relevant to their question. So if you are cross-referencing to another part of the bid, it may be that actually the evaluator can't see that. So you need to be, so you need to be clear from the instructions whether or not you've got to have a self-contained answer. And sometimes that's a struggle when you've got a very tight word count. Bidders are responsible for making sure that their applications are on time. And when you've got multiple appendices and schedules to upload onto a platform, things can go a bit wrong. And so plan to submit early so that you can make sure that you can upload all the information on time. For example, you often hear about cases where people have inadvertently uploaded the wrong information to the wrong section, and then they haven't got time to start the process again. It is important to seek legal advice early on as well if you've got any queries about whether what the commissioners are doing is correct and fair, because then that gives you the best opportunity of making sure that the commissioners are running a fair and proper process. Rachel, do you have any other points to add to that from your experience?
No, that was everything from me too. We've got a bit of time, got 5-10 minutes now for questions if anybody has any. Stephanie, I can't see the Q&A box. Have you got access to it?
Yes, that's fine. Actually, thank you for your questions. We've got quite a few. So I'll go into the Q&A box first. So, okay. So if you've got any questions, please do send them across. First question: would providing clinical and non-clinical training fall under PSR? Have you got enough information about that too?
I think very unlikely to fall under the PSR because you're not delivering healthcare service. So I think outside it. I can double check that afterwards because I haven't been asked that question before, but I think very likely to fall outside it.
Thank you. And where do you have to publish notices of intention under the most suitable provider process?
It's all on FTS. So it is worth signing up to those FTS alerts. And I haven't had a play around with it myself to see whether you can what you can sign up to receive, whether it's just everything to do with particular commissioning of particular services, or whether you can ask for those notices of intention to be sent to you.
And Rachel, you talked earlier on in the presentation about the example of your medical practice where it was dissolved and the commissioner issued a questionnaire. So there's a question about what was the outcome of that.
Still waiting to hear. Yeah, I'm going to be very interested in that one to see how kind of carefully they're applying PSR provisions, because the commissioner in that case is claiming the PSR doesn't apply, but yet has so the PSR doesn't apply, but it was being encouraged to look at the key criteria, and that's what it's done. It's used the key criteria lifted from the PSR.
Thank you. We've got a couple of additional questions. Is the panel review decision published?
Yes. So their obligation, so what they say is we'll publish the decision or a summary of the decision. And what they seem to have done so far is publish both a summary and the decision itself.
One more question. What is the regulatory mechanism? Oops. Where's it? What's the regulatory mechanism to move an APMS contract to PMS or GMS?
I think that's treated as a continuation of your. I know PMS to GMS is treated as a continuation. I'm not sure about APMS. That's probably different. But I suppose there's a potential for. Oh, I see what you mean. So the commissioner would probably want to use direct award C, so the kind of rollover provisions, issue a new contract to an existing provider who's performing well, but it will be perhaps different enough that it would fall foul of the material difference provisions. I'm happy to follow up on that one, but I don't know the answer. Interesting question.
Okay, I'm waiting to see if we've got any more. I'm just going to check to see if there's any more that have come in. I think that's it.
Okay, good. Thanks everyone for joining us. I hope it was useful. And this is a new regime, so it's all very exciting for the lawyers to work out how the new rules are going to play out. So please do get in contact with us if you want just a general kind of conversation about what the PSR means for your organisation or any queries that you've got about it. But thank you very much.